Okay, so we're now being live streamed.
Yes.
For anyone who is watching, we will wait a few minutes before we get started. MJ, how many people are in the waiting room?
I just admitted 2 more. Seems like we're at a pretty critical mass here. Oh, we got a couple more people.
All right, we'll wait 2 more minutes. Do we have, I don't see Representative Gilchrist yet. Is she on?
Is not in the waiting room yet, so I will keep looking and make sure.
Okay, so give another 2 minutes and then we'll see. Bob, I thought you were away as well.
I'm sneaking back in.
Okay. All right. Thank you.
Don't tell anybody you saw me.
Yeah.
Representative Gilchrist is joining now, Senator.
Perfect. Thanks, MJ.
That project brings risk management result of premium income increases.
All right, so I'm going to give it one more minute and then we'll get started. Okay, thank you everyone for being here for the Data Privacy Task Force meeting. It is April 13th, 12:04, and we'll get started. I'll just start by asking my co-chair, Representative Gilchrist, if she has any comments.
Nope, just looking forward to today's meeting. And yeah, thank you.
Okay, great, thank you very much. And then just to lay out, I guess, the how I'm hoping that we'll be able to move forward over the next couple of weeks. As you know, we're kind of getting into the we'll start getting into the busier part of the legislative session. The finance committees wrap up next week, and then after that, we should be going into the House and the Senate more often to vote on final actions. So my hope is next week to have a draft of the children's data privacy language out. We're going to revise that. I have received some red lines from a few different people, so we're going to try to combine some of that feedback, get a draft emailed out by next Thursday would be my hope. And then again, with the hopes of us having another meeting like this. And so on Tuesday, the 26th at noon, if that would work. But we will confirm that later on. But some point in that week of the 26th, 27th, or 28th, depending on availability, to try to meet and discuss the children's language. Today, I asked a few people to present to give their feedback on this most recent draft. And again, the changes were just into the section 1 and 2, I believe, were what we had changed here. So the one thing was just trying to add more, add that consumer healthcare definition to the sensitive care definition. And I asked Michelle Lucan to talk a little bit about other things we may want to add to mirror what Oregon has done. And then also, one thing I noticed is in this draft, it didn't capture everything I was hoping to get in there. In that one of the things specifically I wanted to get in the sensitive information was the biological processes for the period tracking apps. I don't believe we captured that. And so that is something that will work on getting added into that definition of sensitive information. But with that, today I asked a few people to present to give their feedback. So we're going to start with Karen Buckley from the Hospital Association, and then we'll have Michelle Lucan from the Attorney General's office. And then after that, it'll be Andy Kingman from the Privacy Coalition. So Karen, if you wouldn't mind, the floor is yours, and I'll mute myself.
Sure. Thanks so much for the opportunity to comment on the language as it stands. And as always, we look forward to being part of the conversations moving forward as language changes. So I think, some of the remaining concerns in the language as the bill came out of committee, really the main focus for us is section 7, which includes the exemptions, we believe, as intended in Senate Bill 6 last year, which we very much appreciate and think is appropriate. But in section 1, there's some language that says, notwithstanding the language at lines, it's in line, I think, 221 to 229, it appears to draw that exemption into question by saying notwithstanding kind of the other pieces. And so we would love for there to be clarity that the exemptions that were found in Senate Bill 6 continue through this document, and that notwithstanding language, we think, brings that into question. If the intent is to not maintain those exemptions, that would be a very significant concern for us. Just as a recap, the HIPAA has very strict rules on marketing, as it relates to the sale of any data, personal health information. And we think that what Senate Bill 3 is trying to do is kind of apply similar standards or rules to entities that don't currently face HIPAA. And we just want to make sure that there's no confusion out there as to what's required and what's not. And so we would just advocate for that notwithstanding language to be modified so that confusion is eliminated. And then I think the other thing, just in general, and we're happy to kind of work with the Senator and Representative and others, is that the definitions within Senate Bill 3 are not necessarily aligned with definitions that are already found in Connecticut statutes. And we think that they should be aligned so that there's clear governance and clear understanding of what's included and what's not. So again, I think those are solvable things. I will just talk generally and broadly on the issue that's come up on geofencing. And I think I've shared before that geofencing kind of serves two purposes. Fences often do: keep people in, keep people out. And there is an appropriate role for geofencing, both to keep folks out. You don't want people accessing things at records at hospitals for security reasons that they shouldn't be accessing. But there's also use of the technology that's appropriate in healthcare settings. So when you go to your doctor now and you check in online and you fill out all your paperwork and you answer it, that is part of the technology that's there, right? Or if you need directions as to how to get from the parking lot to where you're going for your x-ray, as some hospitals and healthcare facilities use, that's part of what the technology is. So our just general caution is we need to look closely at the language to really address what you're looking to address and to not negatively impact, if you will, the patient care experience and or the ability for healthcare facilities to have appropriate protections in place to prevent those who shouldn't be accessing healthcare information, because we do use those technologies today for security, and all of us don't really know kind of what the future holds in that regard. And then the senator did ask us to talk a little bit about reproductive healthcare rights and language. And I think just the general caution, there's a lot going on this issue, both in Connecticut and nationally. And I think we need to be appropriately focused and cautious that we don't do things that perhaps negatively harm what we're looking to achieve in Connecticut. So that's to say, as things really evolve on the national level, we need to really pay close attention that what we're doing in Connecticut does not put us in a place that creates some new challenges for Connecticut. And not for this bill, but just one of the things that we've identified for legislators is, there's other legislation that's being pursued this session, telehealth, for example, or Connie, right? There's already sharing of health information outside of the state of Connecticut. If the telehealth bill were to pass as it is drafted today, it would allow licensed folks in other states, not necessarily in Connecticut, to access health records for the patients they see. And there are potentially some concerns about someone who's not licensed in Connecticut having access to those health records without any oversight that the state can have. So again, just some policy considerations as we look closely at reproductive health rights. When we look at the availability of prescription drugs, all prescription drugs through the prescription drug monitoring program, there are birth control and other drugs that would be included in that. And we need to look at, when we look at reproductive health care, it's a pretty broad spectrum of health data. It's not just abortions and abortions, right? It really has a broader context in healthcare information, and we need to make sure that we're keeping our eye on the ball and making sure that we're not negatively impacting things moving forward. We're ready to partner on that. I just wanted to flag that there are other bills related on other issues that may be related to the privacy issue that we need to make sure we align with.
Okay,
And I
great.
appreciate the opportunity to talk today.
Okay, thanks, Karen. I would point you, as far as the notwithstanding language, I'd point you to lines 235 to 242, which does make it clear you do still have your entity level exemption. Point well taken on aligning the definitions. Representative Blumenthal had already pointed out a few specifically around reproductive health care that we need to align. So that is something we will be looking at. And then the geofencing, I believe, I hear you on that, but also, I don't know if last June, there was a Washington Post article on this, a company that provides check-in software for free, but nothing is free, right? In order to fund it, they're offering advertising. So again, just making sure that privacy, they wouldn't be a HIPAA entity. So making sure that privacy rights expand there. But I think that your exemptions should alleviate those concerns. So, but thank you, for presenting. And as we go through the drafts, any specific help with definitions in other languages appreciated.
Thank you. And I appreciate you taking me early on so I can hop off for my next meeting.
Yeah, I know you have another meeting. So let's open it. Does anyone else have any questions for Karen? She has another meeting she has to get to. So. All right, great. Thank you so much for presenting. Okay. Next, Michelle Lucan.
Senator, I'll take this one. Michelle,
okay.
She's double booked. Karen's not the only one, so it's a busy
afternoon. Okay, yeah. All right, on if you would.
No, just briefly on the definition of sensitive data. As I think folks know, a number of states this session have introduced comprehensive privacy bills, and many of them are closely aligned with the bill that Connecticut passed last year, SB 6. But one area we are seeing some states expand a bit on our bill is the definition of sensitive data. So I just want to provide one example, which is in Oregon, and that there's SB 619. They have included gender identity, status as transgender or non-binary, and status as a victim of a crime and their definition of sensitive data. Those are currently not articulated in Connecticut's definition. I think some of that may be captured here by the proposed inclusion of consumer health data, but certainly not all of that. And I think they would be worthy inclusions in our definition. As far as I know, those haven't been controversial additions in Oregon.
Okay, great. Thank you. And I know you and some others have brought up that, the definition of sensitive, it did include, right, diagnosis or condition for
Right.
mental or physical health. So I think one of the things we may look at tailoring the consumer health data definition, since that mental health is already included in there, more towards the reproductive health. And so, I think one of the differences that at least that I would see would be like information on seeking those services, right, which I don't think would be brought in, as well as I do want to bring in the biological processes that we have within one of the definitions, but it's not in the consumer health data definition. So, but hopefully you guys would be able to. I know you've been so helpful and instrumental in the bill throughout, so I would assume you'll be willing to help as we try to tailor those definitions going forward.
Yeah, one thing I would note on the definition of consumer health data is I know it's defined as information used to identify people, whereas our definition of personal data under SB 6 last year was more like is used or could be used to identify. So it's a bit broader than actually being used for purposes of identification. So that's one tension we might want to work through.
Okay, great. Thank you. That's great. Great feedback. And I do like adding the status as a victim, right? And especially when you look at domestic violence and other issues, right, that there was the ability to purchase lists of domestic violence shelters and other things online. And we've made it a crime in Connecticut to reveal the location of a safe house, for domestic violence, victims of domestic violence. So I think that status should go in as the sensitive. So thank you for flagging that for us. So does anyone have any questions? All right. So
I'm off the
hearing
hook.
none, seeing none, I think we'll move on to Andy Kingman. So thank you very much.
Hey, everybody. Assuming folks can hear me okay.
Yes.
Yeah. Okay, great. Thanks. Well, first of all, appreciate the opportunity today. Really appreciate the opportunity to work through these issues. I will just say, doing it collaboratively like this is a different process than happened in Washington State. So I think we can solve some of the issues that, weren't able to get solved there. I think from where we are, this language, this latest draft is a big improvement and a big, help and move in the right direction. There are a couple things that I just wanted to flag that we are, kind of working through here. To your point, Senator, I think because sensitive data already includes mental or physical health diagnosis or condition, again, keeping that consumer health data more focused on gender affirming health data and reproductive or sexual health data, I think makes sense. The vast majority of use cases that we, hear about are sort of related to that. And that seems to be the concerns kind of that started this process out in Washington State. And, obviously other states are looking at. So I think that's one thing that we would want to continue to see worked on. I will say that phrase uses to identify is, really critical to us to keep in there, because we are dealing with information that could be health data, but in many cases is not considered health data if the entity is not using it in that way. We think it's appropriate if entities are using it in that way to accept the, stronger heightened protections that come with that. for consumers. But if it is just simply purchasing history of these types of items, you know, to say, hey, do you want to purchase this again? Or you tend to purchase this every month, you know, do you want to, is it time to renew? You know, that's not, that shouldn't be, you know, considered consumer health data. So we view that as a really, really critical dividing line, to make sure that businesses know when they are subject to these heightened protections for the information. I think both with the definitions of gender affirming healthcare and reproductive or sexual healthcare, just clarifying, I think this is the intent, but it right now says means any healthcare related services or products that, and I think just adding healthcare related products, so we make it clear that it's healthcare related services or healthcare related products. The reproductive or sexual health facility, you know, obviously this comes in with the context around geofencing. And I think what we want to not prohibit is, you know, hey, I got my prescriptions from CVS. Hey, FYI, your prescriptions are ready, things like that. You know, I think even just adding the word primarily, so reproductive or sexual health facility means any healthcare facility that primarily provides reproductive or sexual health care. Again, that doesn't necessarily change the definition of the consumer health data. It just means that for the geofencing purposes, it's really related to primarily providing reproductive or sexual health care. And that kind of takes out, I think, a lot of the sort of, you know, gray area use cases of like, well, there's a lot of consumer convenience stuff that isn't about, you know, bombarding a woman who's, you know, trying to get reproductive health care services with targeted ads urging her not to get that, right? I mean, that's, we understand the use case there, not trying to get around that at all. What we are trying to do is make sure that there are, you know, services that, you know, are convenient for consumers, that are kind of everyday transactions, that are not prohibited. So trying to find a line there. But I think if we talk about healthcare facilities that are primarily providing reproductive or sexual healthcare, or primarily providing mental health care, I think that gets us pretty much there. The other piece here, moving down out of the definitions and into section 2, let me just scroll down here. Okay, so section 2A1 prohibits the provision of any employee, contractor, or processor with access to consumer health care unless the consumer consents to providing such access. Not sure that we need section 1, this first provision here. So either 1A or 1B. I think, you know, if a business, let's start, consumer health data will already be considered sensitive data, right? So it will already require consent to collect or to change the use as disclosed to the consumer. I don't think we want to then add additional consent to say to store it on your cloud storage provider or to provide it to a processor. Processors under the law already have a duty of confidentiality. They are bound by contract not to do anything beyond the boundaries of that contract with the data. They're bound to delete or return the data at the end of that. And so I think I don't really think that the consent piece makes a lot of sense here to say, well, you know, we need consent to collect it, and then we also need consent to, you know, store it or provide it to a processor. So I would just say I think that could possibly be removed there. We don't have really an issue with the other two pieces there, so I think we're okay there. And then would just sort of question why, like, I'm not sure we need a separate right to cure piece versus just, given that this is a part of SB 6, I don't think this changes SB 6 at all. So not sure why the right to cure piece would be different here than just the general right to cure pieces. So anyway, that's the majority of our feedback here. Again, I think we're really in the right direction. I don't think any of this is not solvable. Regarding the biological processes that you were talking about with regarding the period tracking app, Senator, I think getting that somewhere in the definition of reproductive or sexual health care is probably a good place for it. I just would, I would hate to see the sensitive data definition kind of become a Christmas tree where we hang everything there. I want to make sure that, that we're really judicious about what does go there. So anyway, that's the majority of our feedback. Happy to take, any questions there.
I think Marion has a question.
Yeah,
Yeah,
actually,
sure.
a couple of questions and comments. So I come from the data privacy space. The company that I work for helps customers, heavily regulated customers, store data on their own Azure tenant. So a couple of things. First of all, the collect versus store data, I think there is actually an important differentiation because where data is stored has a huge impact on the level of security that's involved in that data, whether or not there's a proprietary wrapper around that data, and who owns that data. So in some cases, data ownership would be based on the license agreement between that provider or that so-called owner of the data and where they decide to store it. So just wanted to bring that up. The second thing, and actually what I wrote in the chat, had to do with defining primary healthcare or healthcare being primarily reproductive or sexual healthcare. Having seen what low-income people have to go through, and particularly what college students have to go through to get healthcare when they are at college, they oftentimes have to either go to a health services where the primary focus or function is not necessarily reproductive or sexual healthcare, but should fall under this in terms of data privacy. And for low-income folks, this is not my area of expertise, but I would assume the same goes for them, where there would be clinics that they would need to go to that wouldn't necessarily have that as a focus. And the last thing was what you just said about reproductive healthcare or period tracking apps not being particularly sensitive or don't want to have a Christmas tree of things that we hang on this. I think from a female perspective, that's actually a really critical thing, and that it should not be excluded. I think that there are others here on this call who will have more expertise in that area, but it just surprised me to hear that. Thank you.
Yeah, sorry, just to be clear about a couple things. So what I was suggesting is that the period tracking app reference go under the definition of reproductive or sexual health care, which would be part of consumer health data, which does fit into sensitive data. So it's just a way of being briefer in the way that sensitive health data is defined in the main part of the bill. And then I hear you on the facilities. The only place that the facility in the law is used is around the geofencing, and it's about serving, ads, collecting data, et cetera. And so what we would be suggesting is what we don't want is to prohibit the ability to say, again, hey, your prescription is ready, or, we see you're in the neighborhood. Do you want to pick up, X, Y, and Z? What we do think is completely reasonable is to make sure that, targeted advertisements are not being served again to women who are, seeking reproductive health care, things along that line. So we're trying to make sure that there's a balance there between not prohibiting activities that consumers would find helpful and still protecting, people who, are sort of at a vulnerable point in their process there.
Thanks, Andy, for that clarification. And I think that the concern is if we just left it as reproductive health care is CVS, because, you could be picking up your birth control pills. Is that reproductive health care? So would we prohibit? So I think, but I do get Marion's point that we need to, I'm not sure if primarily, if we need to define what primarily means, like a 70% or I'm not a lawyer, so I need to speak with our LCO on that. But I do like the idea of using the primarily versus exclusively as well, exclusively providing one service, but if it primarily provides just mental health or just reproductive health. So thanks, Marion. Are there any other questions for Andy? And Andy, I think that, correct me if I'm wrong, were you not referring to the right to cure, but to the exemptions when you talk about section 2? Because I didn't think we touched on the right to cure.
No, it
which
looked
means
like, sorry, let me try to find it here. It's line 450. The AG may, in determining whether to grant a special.
Oh, yeah, we hadn't, I'm sorry, that was for the later on piece. We hadn't, okay, yeah, I get
So
it.
that
now.
just
Yeah,
seemed
I
a
should
little
have sent out
redundant
the
with
whole
SB
bill.
6, that's all.
Yeah, that's just old language that
Okay.
we really only amended. Okay. Yeah, I was just trying to get clarity on that. Yeah, no, you're right. That is it there, but we hadn't touched that yet. So we'll get that with next week's hopefully, or 2 weeks. Are there any other questions or discussion? And again, I think the approach that we're trying to take is, unlike Washington State, we do have comprehensive privacy, or as of July 1, we'll have comprehensive privacy in Connecticut. So we thought that we would try to just add this into our existing framework. We didn't need to create a new framework. So that was the thoughts with incorporating this into the definition of sensitive data. So adding those protections, and then with the other protections of the outright, prohibiting the sharing of that consumer health data or the geofencing. So, okay. I don't have any further questions. I don't know, Representative Gilchrist, do you have any questions?
This has just been very helpful.
Yeah, thank you everyone for your feedback. I do feel we are close to getting this. I think Representative Gilchrist and I will probably talk over, the next couple of days, as well as with Representative Blumenthal, and try to get some language that hopefully, I guess until we vote on it, it's never final language, but I feel like on this piece, we're getting very close to getting it. So my hope would be to get that in the next week or so. Obviously, there'll still be some tinkering before it gets voted on, but to get substantially finished by the end of next week, and then to move on to the children's data privacy with that draft going out next week. So, all right, thank you very much, everyone. And we will hopefully circulate an invitation and the next draft language the middle of next week, middle being Wednesday or Thursday. So.
Thank you.
Thank you. All right, MJ, I think we're done. Thank you, sir.